how does this law actually impact the lives of the everyday Chinese?
There is no mention of an independent enforcement authority yet.
It's a great timing to clear some misunderstanding about China's data protection landscape.
The new China Personal Information Law, we're going to be looking at the impact on ASEAN companies doing business in China. I'm going to be your host for this exciting panel to give you different perspective of the China PIPL, right? I'm introducing Mr. Stephen Wong. We're going to be answering the question from a regulator perspective.
I'm Sarah. I'm the head of research in Straits Interactive, supporting consultancy projects in Singapore and Malaysia. I took my PhD in data protection law, particularly on China. So I've been constantly looking at the development of data protection in China. It's very exciting to see the comprehensive personal information protection law is finally passed. I think it is a great timing to clear some misunderstanding about China's data protection landscape.
How important is personal identifiable information privacy to the everyday Chinese? How does this law actually impact the lives of the everyday Chinese?
I've seen the awareness increasing, especially since 2016, because in August 2016, a college-bound student called Xu Yu, she died of heart attack because of her tuition fee was swindled by telecom scammers who bought her personal information online. Because her personal information was stolen, was not properly secured by the database, by the education system. That's why the personal information was leaked, was stolen, and was sold online. So this kind of tragedy, it could have been avoided if there are better data security in place. So since then, people are getting more serious about data privacy. People are asking questions like, who is holding my personal data? What are they using it for? With whom they are going to share? That is particularly concerned on the app's privacy. That's why the regulator asked them to remove the app from the app stores. Right after the government's crackdown on Didi Chuxing, the US share plunged 25%. My takeaway in terms of the concern from the people, from the government is, if you're doing business in China, if you're developing apps or going to develop apps in China, besides the PIPL, the Personal Information Protection Law, be aware that there are also other regulations, particularly talking about the apps.
I want to talk about lawful processing. I'm sure we read about quite often about China being a surveillance state. But now in the backdrop, we suddenly have a personal information protection law. So how does this work, right? Are the laws there going to be governing them in terms of surveillance? Or maybe you can comment about the lawful processing aspect here.
The surveillance has been the hot button areas for the data privacy concern among Chinese. Bear in mind that because, as Stephen said, that this PIPL is a comprehensive law, so it covers the public sector as well. In Article 26, it's talking about when you're collecting image in the public venues. That being said, it's talking about the CCTV surveillance, which is very rapidly used in China. Even if you want to use it, you can only use it for safeguarding the public security. You cannot use it for other purposes unless you've got the separate consent. But even for the public authority, they cannot just do whatever they want. They should still limit the purpose to what they initially getting the personal information for. That is for public security.
My name is Qian Li. Besides my role at Straits, I also lead the IAPP's FIP affinity group. The FIP stands for Fellow of Information Privacy. I also write for the IPP, for the Data Protection Excellence Network, as well as Bloomberg.
The PIPL requires an appointment of a data protection officer. Can you kindly compare and contrast? Because there are a lot of folks on this webinar who are from ASEAN countries.
There are certain circumstances where the organization must appoint a DPO. If you look at the scale, the sensitivity of the data that you're collecting. Now, assuming that you're collecting at least 1 million personal data records, or if you expect to do so within the next 12 months, you not only have to appoint a DPO, okay, the DPO office as well, but you have to ensure that these are full-time appointments. You have to be extra careful, reference the PI spec, know your situation, know whether you have to appoint a full-time DPO, a DP committee.
So Stephen, would you like to comment on the data localization aspect? Do I need to worry about it if I'm in a company with a Chinese operations?
Now, China is not the only country that has a stringent localization policy or legislation. What operators in the mainland of China will have to do, or even those not operating physically in the mainland of China, but having a business connection, in that data will be processed from what they collect from the mainland of China, they will have to bear in mind that if the data is collected in the mainland of China, they should leave a copy in the mainland. So being well informed to give consent, not bundled consent, separate consent, are the core principles of this piece of new legislation.
I want to talk about companies operating outside of China, especially from an extraterritorial applicability. We see that in GDPR. Under the new Thai law, it's also a requirement. The laws in the Philippines have also got an extraterritorial scope. For the PIPL, what does this mean?
If the activities, processing activities, relates to offering of products or services, this is the same in GDPR, or analyzing or assessing the behavior of a person in the mainland. Now this is something like targeting, in the GDPR, targeting or monitoring, the activities of a person in Europe. So the terminologies might not be the same. I think the intention is similar. If you are analyzing or assessing the behaviors of persons in the mainland of China, then it is within the scope of this piece of law. In terms of extraterritorial application of the law is concerned, I think they are very similar. Both legislations are very similar indeed. In the mainland of China, there should be a new culture of personal information protection, that not only should they be regulated or sanctioned or punished, penalized, but also a culture that personal data belongs to individuals, is their personal property, is their dignity, the personal dignity. That's why it is regarded as a right, guaranteed or protected under the Constitution. You can see from various cases over the last few years or months, not only should you penalize those infringing the protection laws, but they should bear in mind that they have a responsibility, accountability, or in other words, that they should help those people, individuals to whom the personal data belongs. They will have the equal share of for example, the benefits arising out of the use or the collection of the data. Recent cases suggest that when a company is sanctioned, fined billions of dollars, these companies will acknowledge in public. They might also make a donation, of another billion or billions of dollars to help improve the community, the entire community in China. This will become a culture as expected by the individuals. Expectation of the community is also one of the factors to be considered. Not only the enterprise, the entity will be fined or sanctioned, but also the person in charge, responsible for this sort of failure, will also be liable to a fine. For more serious cases, renminbi 50 million or 5% of the annual turnover of the previous year may be imposed. It's not sure yet whether the turnover is about the global turnover or just the turnover within China will be calculated or be included for calculation. Not only the fine is a deterrent factor, but also an order of suspension of business or operation for rectification. So suspension of business is an added penalty on top of a monetary fine or cancellation of business permits. This is quite different from some of the jurisdictions in terms of deterrence. This piece of legislation is a powerful one.
You referenced the point about three notable distinctions of the China's PIPL versus the GDPR. Can you just quickly give us a quick summary of these notable distinctions? That's one of the questions that was asked. Yeah.
But the first major one is, I think many people talk about it, even in the mainland of China, is that there is no mention of an independent enforcement authority yet. So in the law, there is no suggestion that there should be, for example, an EPDB or European Data Protection Board, or similar nature to be established in the mainland of China. So now the enforcement rests on the shoulders of departments, ministries, probably in cases where the civil rights is concerned, the People's Procuratorate. Okay, so these three major authorities will share the responsibility of enforcement. No single independent enforcement authority, as in, for example, some of the ASEAN countries or in Europe or in Hong Kong. In Hong Kong, we have a separate independent authority. The second major difference between the GDPR is there is no separate chapter on the exemptions from the protection rules. In particular, there is no exemption for employee data, as it is in, for example, in Hong Kong. Okay, in EU, there is no specific mention about exemption for employee data in the GDPR either. But in some other jurisdictions, there are a specific chapter on exemptions, two on the rights of the employees' data. There is also a mention about this. So this is the second difference. The third one is about privacy by design. In GDPR, Article 25 mentioned privacy by design. I understand that Singapore has done a very an exemplary research on privacy by design a couple of years ago. But in mainland China, there is no such provision for the requirement of privacy by design. So these are the three major differences that I can spot from the recently enacted law in China as compared with the GDPR.
Would you think that the Chinese authorities will actually take enforcement action against companies outside China, or are they more concerned with going after companies within mainland China?
If we have the implementation rules in place, we have gone through the process of investigation, also legal debates. I think the time that other infringing entities, whether they are local or foreign, we'll have to make sure that they comply with the law.
What we have covered is we cleared some misunderstandings. We've given you some insights on what the PIPL is all about, especially the impact on companies who has got presence in China, companies outside of China targeting Chinese as consumers. Those of you who want to know more about the China data protection law, we do have advanced diploma. China's data protection law is covered under the advanced cert in data protection principle. See that we cover all the countries in the region, China along with Taiwan.
Well, this session was brought to you by the Data Protection Excellence Network.
For more data protection resources, visit www.dpaxnetwork.org, the Data Protection Excellence Network, and sign up for free as a member to have full access to all content. Do also like and follow us on Facebook and LinkedIn if you found this useful.